Good morning, everybody. Thank you for joining us. Thanks for registering. This is our fifth webinar delivered during the coronavirus pandemic. It's 10 a.m. and it's Wednesday, the 3rd of June. Changes to the furlough were announced last week, which has created a lot of questions. And the big decision for hospitality venues now is, will they open? Will the staff want to return? How will payroll costs be managed with potentially reduced incomes? My name is Jane Pendlebury. I am the CEO of HOSPA, the Hospitality Professionals Association. I'm joined today by Emma from Boys Taylor, an expert in employment law. She will endeavour to explain the current situation as we know it today. We have received many questions in advance this week, so Emma's already built some answers into her presentation this morning. But I will be asking more questions as they come in throughout the next hour. Please use the question tab on your GoToWebinar app. But I will be keeping all the questions anonymous today, so feel free to ask anything. I won't be attributing questions to people by name today, just because of the topic. Thank you for joining us. I do hope the next hour will be beneficial to you all. I'm now going to hand over to Emma. Thank you, Emma.
Thank you, Jane, and thank you to HOSPA for inviting me to present today. As Jane said, my name is Emma O'Connor and I am a Senior Associate and also Head of Training at Boys Turner Solicitors in Reading. And I've been helping a lot of clients with the job retention scheme, but also looking forward in terms of how we manage our workforce, how we manage our perhaps 2-tier or 3-tier workforce. So I thought what would be really good to do is, and I'm not sure, Jane, how easy this is to set up, but just to really get people to see from the audience we've got today, how many people are using the job retention scheme for their current staff. And Jane, are you able to set that poll up so we can actually get that running? So I think that's quite a useful way to do that. So hopefully now the poll should appear on your screen. You can have a little look.
Answers are coming in thick and fast.
Oh wow, thank you.
Yeah, they're amazing. It's going to be. I think I will close the poll because it's not going to change significantly anyway. I don't think it's so dramatic. Here we go. I'll just share those results on the screen there.
Let's see if we can see those. Yep, you're sharing them. Okay, Jane, could you just read those out to us, just so we know what they are?
Yes, of course. I was thinking everyone would see them. So we've got a roughly 90% saying yes, they are currently claiming under the job retention scheme. 5% have said no, and 5% say they're not sure.
Okay, so that's pretty convincing, isn't it? And these are the current statistics that are on HMRC's website, and I think it's really clear that obviously the amount of employers that the scheme is helping, the amount of employees that the scheme is helping at this time. And as I said, these were up to date as of yesterday, and certainly we're being told that the total government package, so the total support, not just the job retention scheme, but other initiatives that are in place, that the cost could be up to 300 billion. So it's a substantial amount of money that is being used to support employees and employers at this time, but also self-employed workers as well. So let's have a look at some of the key issues. And Jane, we've had some questions, haven't we, about the job retention scheme? I don't know if you want to sort of share those.
Yes, we have indeed. Emma, we can't see your screen at the moment. Did you want to have your screen on share?
My screen or my webcam?
I can see your face, I can't see your screen.
Okay, is the screen on there now?
Yes.
Great, okay,
yes.
That's fine.
It is.
I might take off the webcam just because it helps with the, it makes it a little bit more easier to see the screen. So I think
Absolutely.
the first point there is we've got some of the key issues that have come up, and certainly some of the key issues that I found with advising clients on this. So I think the first concern that employers had was really, where do I start? Because really for many employers, it was as though the rug had been pulled completely from underneath them when lockdown was announced, particularly in the leisure and hospitality sector. And I think the main concern was really, how do employers balance the need for fairness, but also this need for business necessity and survival? And one of the key problems we found was with communication, and employers making that decision straight away as to who they were going to place on furlough, obviously making sure that they were fair, they were not using any discriminatory criteria, following our equality laws to place employees onto the furlough scheme. And employers had to work really, really quickly to do that. And I think the ones that got it right were the ones that had clear communication. They were able to connect with staff, to inform them about what was going on within the organisation, and to take those decisions quickly, but also to ensure that they had engagement from the staff as well. So I think communication has been a key issue, but also it's a continuing issue as well for employers, and this clarity of planning and decision making, particularly as we move through now to looking at reopening our workplaces, at getting our people back to work. Another sort of tip I would have is that if you have placed employees onto the furlough scheme, it might be worth going back and having a look at those furlough letters, and particularly with the changes that have been announced, but obviously the changes that are coming as well up until October. So I would urge you to go back and look at your furlough letters, and also to make sure that you keep any documents, your letters, any information with regards to pay, to benefits. I would be looking to keep those until October, the end of October 2025, because I think that the messaging from HMRC is certainly that there will be some auditing taking place. So please do keep hold of your documents there. We also had lots of issues about what is wages, what can we include within the calculations for the JRS. And I found myself in situations where I was telling one client on a Monday, yes, this was included, and then we got guidance overnight and I was having to call them back and say, no, it's not included on a Tuesday. And that was particularly true of tips and troncs, which we know are not included within the calculation of wages for the job retention scheme purposes. Another key issue with the job retention scheme, and actually for employees who are currently working as well, concerns holiday and holiday pay. And the guides that were coming out from HMRC were silent on what employers should be doing about holiday and holiday pay. We knew that holidays accrued during the furlough leave period, but what do we pay people when they are taking holiday? And actually, are people going to be taking holiday if effectively they are not working? So we had lots of issues around that. And I think now we have lots of issues about it, because obviously we have lots of people who are either working or not working who are accruing lots of holiday. And what employers perhaps don't want is, when they do start to reopen the workplace, they don't want people then taking holiday when they really want them to be working. So we know that holiday pay, when employees do take holiday, that whilst that doesn't interrupt furlough leave, holiday pay would be based on 100% of employees' normal wages. So what we're seeing there is a top up of 20% from employers having to pay that additional sum when employees are on holiday. But obviously, as I've said, we've got this holiday that's accruing. And not only that, is that obviously if employees do leave us, if their employment does terminate, then employers have to pay for the accrued holiday up to the termination date. So again, that's going to be, for some employees, quite a large sum of money. So where does the law help us? Well, there were new holiday leave rules that were introduced, which allow workers, because the ability to take holiday is a right not just for employees, but for workers as well. So we have rules which allow employees and workers to carry over for up to 2 holiday years, 20 days basic holiday. And that's really where they've been prevented from taking holiday because of COVID-19. designed for our frontline workers, our key workers, those individuals who have been unable to take holiday because of work needs, of pressing work concerns, national emergency, etc. So some issue there with whether those rules apply to people who simply can't take holiday because there is nowhere to go. But there are rules in place there that help us. Some employees are being told by their employers that they have to take holiday. So employers are designating holiday to be taken, either during furlough or for employees who are working. But remember that if you are looking to designate holiday to be taken, that you must give twice the amount of notice for the holiday that you're wanting to take. So for example, if you're wanting an employee to take 5 days holiday, you need to give them 10 days holiday. So some employers are looking at 3 weeks of furlough, 1 week of holiday, but of course giving that correct notice period there. So I think as we move forward, particularly to the end of October, to the closing of the job retention scheme, I think holiday and holiday pay is going to be an issue. So I would urge you to have a look at that now to see whether the rules that are in place with regards to being able to designate holiday might actually be something that you want to take advantage of at this stage.
It'd be great when we can actually go away on holiday. So as we start to lift the lockdown and move forward to reopening businesses, many hotels and hospitality venues will be thinking about reintegrating their workforces. What issues do you think will be coming up there, Emma?
Well, it's really interesting, and I think that, you know, for some businesses they are managing a 2-tier workforce, so some workers working remotely, some workers on furlough scheme, and for some businesses they're looking at a 3-tier workforce, so some individuals who are actually working on site, some individuals who are working remotely, and obviously some that are on furlough. And that really does cause challenges for businesses, particularly, as I've said, around the communication, trying to keep our people engaged, holiday issues as well. So there's lots of workforce planning that's going to have to be undertaken by employers as we look to, as you said, open up the workplaces and get people back to work. Flexi furlough, the flexible furlough may help us, and I'll come on to talk about that, obviously from the 1st of July. But for some individuals, they will remain on furlough until the end of October. So again, it's about keeping those individuals engaged in the business. Some businesses might want to look at using rotating of furloughed workers, so maybe 3 weeks of furlough. Remember, we have to keep this minimum of 3 weeks period on furlough leave to be able to claim under the scheme. So maybe looking at 3 weeks on furlough, 3 weeks back at work, and so on and so forth. And that might help individuals back into the business at this stage as well. And also, you know, now is the time to be thinking about the job retention scheme, particularly for those businesses who are paying the top up of 100%. Is this something that the business can sustain, particularly when we begin to look at the rules that are coming in with the tapering off of the support to businesses? That's something to be thinking about. And also, we've had questions about, well, I want to bring my people back to work. How much notice do I need to give? And certainly, I think, you know, 2 days notice, but again, it's going to depend on the circumstances. So lots of workforce planning there, not just in the health and safety area as well, but particularly around the practical side of getting people back into the workplace.
Great, okay. You mentioned there changes to the job retention scheme, which were announced last week. What can you explain what those changes are, Keith?
Yes, so there's effectively three changes. The first is flexible furlough. The second is the closing of the job retention scheme to new entrants. And then we have the tapering of the grant as well. Now, at present, we don't have the full guidance. What we have is a fact sheet that's been issued by the government, which gives us sort of some core details about what's going to happen. And I will send that fact sheet round, because actually it's quite a useful document to have at this early stage. But I think I'm going to break them down into sort of the three changes. So flexible furlough or flexi furlough. Now this is being introduced on the 1st of July, not August as was previously discussed by government. So from the 1st of July, employers will be able to bring back furloughed workers, so employees and workers, back to work on perhaps a part-time or a shift basis, while still being able to access the job retention scheme, so still being able to access the grants. Now, the government have explained that they're wanting to do this to allow businesses to, if you like, dip their toe into reopening, because some businesses will find it stop-start to begin with. So it allows businesses the opportunity to gradually bring employees back to work whilst still being able to access the grant, in the hope that redundancies and other options to reduce wage bills and costs will be averted. Now, the hours that your flexi furlough worker can work can actually vary from week to week, so they don't have to be brought back on a set amount of hours every week.
Okay, we've got a question here about the mechanics of flexi furlough. Is there any more you can say on that?
Yeah, so I think the key point is going to be employers are going to have to find a mechanism to be able to record the hours that the worker is working during the claim period. So effectively, if employers are wanting to use flexi furlough, then they need to agree in writing. And again, we need to keep those records, keep that information until October 2025 for auditing purposes. So agree in writing that your employee will return and do some work, which will be less than what they are currently employed to do. So less than their contractual working hours. But they are still on furlough, they are still a furloughed employee. So what's going to happen is during those hours that they are working, they will be paid their normal contractual pay by the employer, plus the employer will obviously pay employer NICs and any pensions and any other benefits that are associated with those working hours. But for any hours the employee is not working, and that's calculated against their contractual hours, so their normal weekly or normal monthly hours, employers will be able to claim the furlough grants, as they're doing now, of up to at the 80% rate for those hours worked, plus for July at least, any corresponding employer NICs and pension auto enrolments. So that's how the split is going to work. The £2,500 cap will be applied, but it will be applied proportionately to the non-working hours. So, for example, if the employee is working 50-50, so 50% of their time working, 50% non-working, then the grant cap would be reduced proportionally to the hours that the employee is not working.
Okay, I know that we don't have full guidance on all of the changes at the moment, and general feedback has been that it was a fairly simple process at the beginning to go through the furlough, although there were a few hiccups along the way. Do you foresee any difficulties for employers using the flexible furlough?
Yes, I can, and I think I put up on the screen there some of the thoughts that I've had about how this is going to work in practice. And as I've said, I think the main issue is going to be around how can employers accurately record the hours that the employee is going to be working, because it's looking at hours. And so the employer at the moment, what it's sort of saying in the fact sheet is that the employer will have to, when they make their claim, say for example over the 3-week period, they're going to have to be able to say the employee works X hours normally under their contract, but they've worked Y, and how can we justify what the Y is and support what those hours are. So employers now need to be thinking about how can we have this accurate time recording issue. So we need to think carefully about that. We need to agree the change in writing, so again we need a written record of what we've done. I can foresee a huge issue and actually we did have a question about it, Jane, didn't we, about how this works with 0 hours workers. And yeah, this works great if you are a worker who has fixed hours every week or every month, and you work a percentage of those hours and your pay is fixed. I think it's going to be relatively straightforward to work out the hours that you've worked. But obviously with our variable hours, with our casual workers, with our 0 hours workers, they can work variable hours from week to week. So what is their normal contractual hours? So I would imagine what we're going to see is when we see the guidance, there will be some form of way of working out average working hours as we do work out average pay. So perhaps we have to work it out over the previous 12 weeks, maybe looking back from the 1st of March. It could be that we look back over a year. So there's going to be some issue there with obviously our variable hourly workers again. So I can see there being some issues on that. There's also the issue, of course, is that if we do bring back furloughed employees, what's the situation if we've agreed pay cuts with our existing workers, so our employees that were non-furloughed? What happens there? Because, of course, if we bring our furloughed workers back on their original pay, then of course this is unfair to the workers who have accepted a pay cut. And certainly right back in the beginning, where we had the first HMRC guidance, we were told that if employees had previously agreed a pay cut, then they could not be a furloughed worker. They couldn't join the furlough scheme. So at the moment, this is a bit of an issue. And whilst I can see that furloughed employees can return on a reduced pay, so they are in line with their fellow workers, of course, then the question is, what do you claim via the JRS? Do you claim pre-furlough pay, or do you claim the new reduced pay? So I think at the moment, where there has been pay cuts, this is an area where we need to await guidance. So start looking at your workforce, start thinking about those individuals who you want to bring back. But I think at the moment we just need to be aware that where there has been a pay cut in place, we're not sure at the moment how that's going to work when we bring our furloughed workers back. What are they going to be paid and what can we claim back through the grant? Also, just remember that when workers are working, the definition of their pay, their calculation of their pay is going to be different to obviously what's included within the definition of furlough pay. So again, some payroll issues there, some calculation issues there. So flexi furlough, I think a good idea in theory, but I think we need to await the detail, as I've said, particularly around pay cuts and particularly around our variable workers.
Okay, we're getting a lot of questions about the job retention scheme being closed to new entrants, but I think you're just about to come on to that anyway, aren't you?
Yeah, perfect timing, perfect timing. Yes, so the next change obviously looks at closing the scheme to new entrants. So again, another date, the 30th of June. Now, again, looking at the details that we have in the fact sheet, the job retention scheme will close to new claimants from the 30th of June 2020. But because we have to put those who are going to be on furlough for a minimum period of 3 weeks, we need to have put our furloughed workers onto furlough by the 10th of June. So we need to really diarise that date. So that's for new entrants. So for those individuals who have not been on furlough before, let's look at where we are now with our workforce planning. Do we need to put people onto furlough? If we do, then we need to do it by the 10th of June. But I'm going to give a bit of a kind of a warning on this. Throughout the whole of this, I've been very much thinking about this scheme in terms of the wording. The wording of the guidance that we've had has always been very, very specific and very, very carefully chosen words. But I think we also need to look at the spirit of it. Now, in the fact sheet, it says that those new there seems to be an issue with regards to how many people employers have already claimed for. So the fact sheet says that the number of employees an employer can claim for in any claim period cannot exceed the maximum number they have claimed for under any previous claim. Now, to me, that seems that there's sort of one in, one out system, because perhaps the government don't want a further tranche of new people joining the scheme, claiming under the scheme. So I think we just need to watch out that there potentially looks like there's going to be some caps on the numbers of employees employers can claim for under the scheme. So it may be that if you've got some workers who have returned to work, you can then add some new claimants to the scheme, but certainly I think we just need to watch out where we are with that fact sheet and that wording at the moment. The other point I will make is that obviously if we are going to place individuals onto the furlough scheme, they have to meet the criteria. So again, they have to be a qualifying worker, so there has to be no work for them to do. They have to have been notified through the HMRC's real-time information, the RTI information, as at the 19th of March 2020. So it's not going to apply to new starters. We're looking at new entrants to the scheme, but obviously they must meet the original criteria. And again, the criteria around employers having a UK bank account and again, being enrolled for PAYE online. So I think the closing of the scheme, we need to look out for. We need to keep that 10th of June date in mind, but I think we just need to be aware that there could be some limits placed on employers about the number of people they can claim overall.
Okay, so we have a number of questions about when employers will have to start contributing to the wages of furloughed employees. So one here says, can some clarity be given on how the employer-funded furlough top-ups required in September and October will work?
Yeah. Okay, so what I put up on the screen here, this was actually a graphic that appeared on HMRC's website, which gives you that sort of percentage breakdown. So flexible furlough from July, but still the employer, still the JRS for those employees who are not doing any work will cover the full up to 80%, up to the £2,500 cap. But then things start to change from August, and we're going to start to see some tapering off. So let's have a little think about where that's going to, what that's going to mean for employers. So from August, the government will continue to pay the 80% of wages for furloughed staff capped at £2,500, but employers will have to pay employer NICs and the pension contributions, so the auto enrolment pension contributions. But that's obviously for the hours that the employee is not working. So here we've got this bit of complicated calculations that are going to have to be done where you've got people on flexi furlough. So we just need to bear that in mind. From September, that's when employers need to start contributing to the actual physical wages. So the government will pay 70% of wages, capped at £2,187.50 for the hours the employee does not work. Again, we're still looking at furlough pay. We're still looking at that 80%. And employers will pay 10% of wages. Again, wages is furlough pay. So that's going to be up to, according to government calculations, £312.50 per furloughed worker. And again, it's to make up that 80%. The caps still apply. And also from September, then again, employers will need to pay employer NICs and the pension contributions. So that's still there as well. From October, again, we've got a bit more of a levelling off. So the government will pay 60% of wages, again, it's furlough wages, capped at £1,875 for the hours the employee does not work. And employers at this stage will be paying 20% of wages, again, furlough wages, and that will be up to £625 per furloughed worker, plus employer NICs, plus auto-enrolment minimum pension contributions, again, for those hours that the employee does not work. So in all cases, the cap will be reduced, as I've said, by the hours that the employee is not working. But as far as the government is concerned, as they've put there, that's the maximum cap that they're looking at. So £2,190 for September, and October £1,875. If employees are working under the Flexi Furlough scheme, then of course that's going to make those calculations slightly more complicated, because obviously there is, when workers are working, then of course the employer has to pay normal wages, and obviously take that into account when they are making the job retention scheme grant. So I can see it's going to get tricky, particularly where individuals are coming back and doing some work from July. But certainly the job retention scheme will end in October. There has been no murmurings that the scheme will be extended beyond that.
Okay, and a question here, employers presumably are still able to top up, there's no changes to that?
No, there isn't. Employers are still able to top up to 100% of pay at their own expense. But as I've said, with the scheme continuing until the end of October, with Flexi Furlough, with maybe some people coming back and working rotation, it might be a time to have a look at the terms of your furlough scheme. But again, if you are looking at changing the terms of it, we need to write to our employees and tell them what we're doing.
Okay, there's lots of questions coming in about this, but perhaps we collate those and then put out a message afterwards, because they're coming in thick and fast.
About the job retention scheme.
Yes,
yeah,
there's lots, and what different people can do. But I think in the interest of time as well, we probably need to just put that to one side for a second. But I think to reassure all those questions coming in, we can perhaps answer some of those post the live webinar. The next sort of tranche of questions that I know you're happy now to talk about contract terms. A lot of people seem to be having their contracts amended as a way of preserving jobs and at the same time reducing costs for the business. How do employees and employers stand there, Emma?
Yeah, and certainly a lot of businesses I know did, looked at changing terms and conditions before the job retention scheme was announced. So it was sort of, the first sort of action that was taken. There was unpaid leave was used. Employers looked, if they had the terms in their contract, looked at short time and lay off, that ability to, where there is no work for individuals to actually, there is no work, they don't work, and they can claim guaranteed payments from the government. And certainly those clauses, the short time and the layoff clauses, I'm getting lots of feedback from clients that they want those clauses back in their contracts. They are popular in the manufacturing industry, less so, particularly in the services industry. But again, now's the time to really go back, check your contracts. Is there any way that we can help the business in the future should we need to do this again? So again, have a look at your contracts. Let's use them in the way that as a business tool. Our contracts as they stand now, there is some element of flexibility in them to allow for sort of minor changes. But I think if we are looking at changing the fundamental terms around pay, around hours, those other core terms, then employers need to be careful, because if we start unilaterally imposing those changes, forcing those changes upon our workers, then for those that have the 2 years service, they can resign, claim constructive unfair dismissal, because effectively the employer is breaching the term of mutual trust and confidence, as we call it. So there are risks there about imposing changes. So what do? We inform our staff that we want to make these changes. We give a period of time for them to raise any questions, and then we say from whatever date it is, this is the change and this is what it's going to be. I mean, hopefully these changes are temporary, but obviously we need to get the employees' consent to do that. Difficult when people are working remotely, but not impossible via email, via Survey Monkey. I've seen that being used as well. But essentially, if we are changing those core terms, then we can't do so unilaterally. Another point I want to raise is if the employee doesn't agree, and what I will say is at the moment, I'm not aware of any client who's had an employee refuse to sign because, you know, what are the alternatives? Well, the alternative is if you don't agree to the change, then we will give you notice under your current contract, we will effectively dismiss you and we'll look to re-engage you. But just a word of caution about that. In certain circumstances, that can actually be a redundancy and can trigger, depending on the numbers, collective redundancy consultation obligation. So if you are looking at making contractual changes, then I would always urge you to take specific legal advice on it, because just of those consequences, particularly around redundancy. Again, please do watch out for that.
Redundancies is a very hot topic. You know, it's pinging away asking about redundancies, and how a business stands on making redundancies whilst the job retention scheme is in place.
Yeah, I saw that we'd had a number of questions about that, and it's a really interesting point, because we've had lots of discussions amongst our team at Boyce Turner about you know, what should we be advising clients at this time. And you know, it's right that, you know, the purpose of the job retention scheme is to support employers to avoid having to make redundancies. And again, the fact the schemes have been extended to October shows that there is support there as we move through this transition period to reopening. So you know, the answer is going to involve probably discussions that are outside the remit of this webinar. But I think if we look at the actual terms of the job retention scheme, and this is where it gets very interesting, you know, this is the purpose of it, is to preserve jobs. But actually the scheme, the guidance for the scheme actually says that employers can make redundancies during this time. And again, it says in the employee guide, the HMRC guide, that you know, employees can be made redundant whilst on furlough leave and whilst in receipt of government funding, or indeed can be made redundant afterwards when they go back to work. So unlike other European jurisdictions, which have said quite clearly, if you are receiving government funding, you can't make job cuts, the UK has chosen not to do that.
Okay, perhaps it's harder to justify as a genuine reason while they are getting support.
Yeah, I think that's true, and I think whilst, you know, there is no legal right to be placed on furlough, it's the employer's decision to do that, you know, based on the fact there is no work, and provided obviously the worker meets the conditions. But of course, if an employer is choosing to make redundancies, that redundancy situation must be genuine. There must be a genuine need to make redundancies, and perhaps the job retention scheme will make that that ability to justify the redundancy a little harder, and make it more put the emphasis back on the employer to say, yes, there was this help in place, but that did not help us because. So I think employers need to think very clearly, because of course, you know, there's lots of media, you know, the media is great, isn't it, at highlighting all the baddies, all the bad employers out there, particularly where they are using the job retention scheme to pay notice pay. That seems to have been a big hit with social media at the moment. Those individuals, those businesses who are using the job retention scheme to fund notice. But certainly there is nothing within the scheme rules that will stop individual employers from making redundancies at this time. But I guess that's only really one part of it. You know, it's very clear that when we look at redundancies and when we look at the HMRC guide, it's very clear that although workers are on furlough, they do not lose their employment law rights. So rights to equality, to you know, our anti-discrimination laws, our anti-harassment laws, our rules with regards to changing terms and conditions of employment, as I've already mentioned, our rules around fair dismissals, our rules around redundancy, they still apply. And I think that's really important to remember, is that, you know, this situation, whilst I can see courts and tribunals being sympathetic to employers at this time, certainly there are still expectations that the rules around fairness, around dismissals, around redundancies will be followed. And you know, talk about redundancies, and I'm conscious of the time, Jane, you know, is a whole hour of it on its own. But if I can just sort of flag some of the key issues there, you know, we've got to think about our individual consultation, putting individuals at risk of redundancy, fair selection. So again, not picking everybody who's on furlough leave, because people on furlough leave may be shielding, they may qualify under disability laws, under equality laws. We need to be very, very careful about who we pick. Certainly for some businesses, they were contemplating redundancies before the lockdown, before the scheme happened. For other businesses, despite the help, it's not enough to sustain their business. And for others, they may be looking at it in terms of, you know, how can the help support us? But also as we move forward with the tapering, does that mean now that we can't support all our workforce? So we just need to think about that genuineness of the reason. You know, it's a potentially fair reason to dismiss an individual, but we've got to ensure that it is genuine, and also that we follow a fair process. And I've put up here that obviously if we're looking at making 20 or more people redundant at one establishment, at one location within a period of 90 days or less, then the collective consultation obligations are going to kick in. So we need to think about our minimum consultation periods, 30, 45 days, depending on numbers. We need to think about getting in Form HR1. If we don't do that, it's a criminal offence, really important step. We need to think about electing staff reps. We need to think about training. You know, and then we need to think about the financial risks, the unfair dismissal claims, the potential discrimination claims, but also the penalties there if we don't follow the collective consultation regulations there around the protective award of up to 13 weeks actual pay per employee. So redundancies is a whole topic on itself, but I think my advice is, if you are contemplating redundancies, you do so and you start the process in good time. But the devil in redundancy is in the detail, it's in the preparation and it's in the planning, particularly where you've got to do your preparatory steps, your Form HR1, your electing of staff reps, before you actually get to the consultation period. And you know, it's going to be harder. People are working remotely. How are we going to consult with them? How are we going to consult with them fairly? How are we going to hold town hall meetings, surveys, elections? So all of that practical, logistical stuff is going to make an impact, and will impact upon the speed at which you are going to be able to start that redundancy consultation. So get planning and ensure that you're acting fairly.
Okay, I know probably Emma's now a good time to plug your second webinar that you're doing tomorrow, not with HOSPA, without because we discussed that.
Yes.
So do you want to just say that?
Yeah, no, I will do. So what I will do is, Jane, is I will share that link for people who want to join us tomorrow. I'm doing a redundancy webinar tomorrow because I can't cover it off in one slide, unfortunately. So please, if you're able to join us tomorrow between 11 and 12 again for another live webinar, if you want to listen to me again and my colleague Barry Stanton, you are more than welcome. But Jane, I'll feed that through to you.
Great, thanks, Emma. I've got one here because I think a lot of what you said there applied to the larger business. If it's a small business and they just want to make a single person redundant whilst they're on furlough, do they need to come back off furlough for their notice period, or can the notice be served whilst they're still on furlough?
Yes, the notice period can be served whilst they are still on furlough leave, and you can claim the 80% through the furlough scheme. So yes, you don't have to return to work.
Another quick one here. What about staff members who are on probation at the time of lockdown? Does the probation period have to be automatically extended, or can it be brought to an end either one way or the other?
Well, with probation periods, I suppose it depends as has the individual had an opportunity to be able to complete their probation. So I suppose it's not so much a legal question, but really a practical question. If you feel as an employer or as a manager that the individual has not had the opportunity to get to grips with the systems, to actually do the job that they've been employed to do, then perhaps the fairest thing would be to extend until perhaps the end of October, if the individual is going to come back on Flexi Furlough. So I think, you know, you need to think about the practicalities of it. Has the individual been able to, they won't get unfair dismissal rights until they've reached 2 years service, unless there's obviously an automatic unfair reason, but they will have discrimination rights if they have a protected characteristic. So, you know, it's one to look at the risks, but also look at the practicalities and has this individual been given a fair crack of the whip?
Okay, and I'm very conscious of the time. I just want to pick up on something that we covered. I had a lot of questions at the time about holiday pay. So that's way back at the beginning of your presentation. I think you said by mistake that employers would need to give 10 days holiday. You said about taking 5 days holiday. They would have to give
10 days notice.
10 days notice.
Yes,
yeah,
that's correct.
So that's so it's 10 days notice rather than 10 days holiday. So normal amount of holiday, just additional. Twice the amount of holiday in notice.
No. If you just to repeat, Jane, you have to give twice the amount of notice for the holiday you are wanting the individual to take. So if you want your individual to take 5 days holiday, you must give them 10 days notice.
I think there was a bit of confusion about that at the time. It's difficult to manage these questions, if I'm quite honest, because there are so many of them. And so I think I'm going to have to ignore all the redundancy ones and just refer all of those lovely questions to your
join us tomorrow, please. Join us tomorrow.
Yeah.
And hopefully they will be answered. But, you know, it is a really worrying time. And I think that, you know, as I've said, the devil with redundancy is in the preparation and the planning. You know, how are we going to do this logistically? How are we going to elect staff reps? You know, are we going to be able to consult with individuals? Who is going to consult with them? You know, it's those practical and logistical issues that I think are going to actually give employers more of a headache. You know, once you get to the consultation stage, so if you're holding your staff rep meetings and your individual consultation meetings, don't forget in collective redundancy, we've got to do both collective consultation and individual consultation. And then don't forget, of course, that when you are looking at, you know, individual consultation, you know, ensuring that individual's had an opportunity to meet with their manager, you know, giving them the right of appeal. Again, that's really important to really make sure we have got that process as fair as we can do given the circumstances.
Okay, moving sort of slightly away from redundancies onto resignations. If an employee who is furloughed decides to resign whilst furloughed, would the notice period be payable at the furlough amount? And in this particular instance, they are capped at 80% and to the maximum of 2.5.
Yeah, it's a really tricky one, notice pay, and it really does depend on what the contract of employment says in terms of whether they are on statutory minimum notice. I think what I would do in that situation is obviously check the contract, see what notice the individual has to give. I would probably pay it at 80%, and I might just be slightly, yeah, I would recognise there's a potential risk there of 20%, but I would probably pay it 80%. Okay.
Brilliant. Now, I know you want a little bit of time to sum up, so I don't know if you want any more live questions now.
Actually, there was one that somebody sent through, and you messaged it to me this morning, Jane, and I thought it was quite interesting. So this is an individual, and I've written it down to the summary. This is an individual who is a part-time worker. They are currently furloughed, and the business want to bring them back from June on a part-time basis. Sort of part-time, and we're wanting to know if in June they could claim back for the hours that the part-time worker wasn't working? The simple answer is no, you can't do that. Let's remember that the purpose at the moment, the condition at the moment with regards to the job retention scheme is there is no work for your person to do. So if there is work for your person to do, then unfortunately they are not a furloughed worker. So your options are, I think, they remain as a furloughed worker, and perhaps we look from July to bring them back on this flexi furlough, which was probably the best thing to do. But certainly, you know, the condition is at the moment that that individual, there is no work for them to do.
Okay, it's tricky, isn't it?
It's very tricky. I'm going to put my camera back on now and see if that works. There we go. Yeah, so I just wanted to really summarize, because I know we've covered a lot of information at the moment, and I do, you know, appreciate this is a very difficult time, and I also appreciate, and I found it very frustrating as a lawyer as well, that I like to be able to give answers, and I don't like having to say we have to wait for the guidance, but unfortunately we have to wait for the guidance. So my sort of summary is really keep up to date as best you can do with what's going on. I think communication, that clarity, particularly around how we're going to manage the workforce moving forward, how we're going to reopen. We need to listen to our people. Our people are going to be very concerned at the moment, and we need to be able to respond to them and help them. I think we just need to be flexible and agile in our plans. And certainly, you know, the businesses I know who are looking at these issues now, are looking at workforce planning, are being able to adapt, are being able to manage issues much easier and much smoother than those that aren't. Please keep your records. I can't stress that enough. I think we have to assume that there is going to be some auditing here of, you know, the claims that have been made. Redundancies, the devil's in the detail. Please do join me tomorrow. And I think also we just need to think long-term, short-term. You know, lots of businesses are looking at how we can perhaps use what we've learned, use the technology, use our ability to connect remotely, and actually focus on some of the positives. You know, keep our communication going with our customers, using social media to promote the steps that we're taking, thinking about our culture and our brand, but also take a breath. You know, I know from talking to HR managers, from business owners, this is a really difficult time. So do take a breath and take some time to really plan what you want to do using what we know so far from the government support that is available. So thank you very much. And I have just put up my details there if anybody does want to contact me. And as I said, I will share the details of the webinar tomorrow. And Jane, if you could pop that on your LinkedIn or share that through the HOSPA website, that would be amazing. So thank you so much for asking me to join today, and appreciate it's been a sort of a very quick hour-long debrief.
A whistle-stop tour,
yes.
All very interesting. And yes, to pick up on your points just then, communication is always the key to success. So if people just to clarify, I think with your employees and your employers, if you're listening, with your employee hat on as well, and take a breath. What good advice for everybody. My personal experience of people on furlough have been loving the sunny weather, but maybe getting bored, and those that aren't furloughed, working full time, seem to be working, if it was possible, twice as hard as before. But thank you very much, Emma. Really appreciate that. I just want to remind everybody that the advice given this morning is general and should not be assumed to be right for every single situation. The landscape is changing with rapidity. So whilst the facts are correct for today's position, that will change as the days and weeks pass. If you need formal advice, please contact me and I can put you in touch with Emma. She has put her details there in the chat box as well. And we're flooded with experts in many areas of hospitality here at HOSPA. So obviously legal, and today's topic Emma is perfect for that. So please do get in touch with Emma or me directly, is fine. A big thank you to Emma, thank you.
Thank you.
And all the insights you've shared with us today. As I say, I've got a bit overwhelmed by the questions today, and I know there's a lot unanswered, so I'm hoping we can revisit those.
Okay,
we do post the webinars on the website, usually within 24 hours, so there will be a recording of this with the slides, and also some key points highlighted. So please do visit the HOSPA website. Also on there, we continue to update our crisis support page, and also the positive news we are sharing during this time of the COVID-19 pandemic. And not just this webinar, there'll be all the previous webinars up on that webinar section. It's just hospa.org/webinars. Next week, there's a slight change in our schedule. On Wednesday, there's an in-stream event involving Russell Kett, who many of you will know from HBS. Russell is a great supporter of HOSPA and one of our long-standing fellow members. He's running a webinar next Wednesday morning in conjunction with a couple of partners. So I would strongly recommend registering for that, and please come back to me for more details if you'd like them. We will be running a webinar on Thursday next week, slightly longer. We're starting at 8:30, going through until 10. This is a regular finance update that we do in conjunction with BDO. It's always a very popular event, so please register for that on the HOSPA website and keep yourself up to date with all the finance regulations and current recommendations. So that's it for today. Thank you all very much for listening. We look forward to seeing you again next week online and being able to get together in person again very soon. And another big thank you to Emma for today.
Thank you very much. Goodbye.
Thanks very much. Goodbye.